Good morning, afternoon, and evening, ladies and gentlemen. I know we have quite the global audience today from various parts of the world. Thank you for taking the time out of your busy schedules to join our session today on estate planning for Americans with Bonnard Lawson. I'm Aviel, better known as Avi, and I'm the financial administrator here at Dunhill Financial. Just a bit of housekeeping and a brief rundown of the format for this webinar before we get started. We will be putting everyone on mute as soon as the presentation begins. Please feel free to ask any questions in the chat, and we will do our best to answer them for you as we go along. However, we also have a Q&A section towards the end of our presentation for you to ask any questions you may have. A few disclaimers before we go through. Dunhill Financial LLC is a registered investment advisor. Information presented is for educational purposes only and does not intend to make an offer or solicitation for the sale or purchase of any specific securities, investment, or investment strategies. Investments involve risk and, unless otherwise stated, are not guaranteed. Be sure to first consult with a qualified financial advisor and/or tax professional before implementing any strategy discussed herein. Now, with that out of the way, I shall hand it over to Brian.
Thank you, Avi. First and foremost, a happy St. Patrick's Day to everyone. And as we're prevented from drinking those green plates of beer, we'll endeavor instead to reach out for that pot of gold at the end of the rainbow. I promise the jokes will only get better. Today, we're lucky to have three wonderful attorneys from Bonnard Lawson that are experts in their relative regions, and they all help Americans on their estate planning needs. We have an ever-changing landscape when it comes down to estate taxes, between the potential changes that the Biden administration might bring about to sunset clauses that will inevitably happen if Congress does what they do best, which is nothing. And also the potential for regional changes, as some of those that are presented by Macron in France, and also how the Brussels IV amendments could affect anybody in Europe. All Americans should first see if their respective countries have one of three documents: a double taxation treaty for their regular taxes, a totalization agreement for their Social Security contributions or distributions once they get to retirement, and an estate tax double taxation treaty. Many countries will only have one, but not all of them have all three. So be prepared to understand how the different ones work. The legalities of still wanting all the protection of the four documents that every American should have: a will, a trust, a power of attorney, and a healthcare surrogate, should all continue to be needed as an expat, but maybe in a different form depending on where you'll reside, how long you'll be there, and where you might be thereafter. That being said, the financials are the easy part. Make sure to concentrate not just on the taxes, but on the legacy that you want to leave. Whether that is charitable items, not just the financial portions, family heirlooms, important momentums, and the like, don't forget that the notes and wishes you have for the next generation are all access points where you might keep the family photo album these days, maybe on your laptop, maybe on social media, instead of just in the attic. We have three wonderful guests, as I said: Dr. Guillaume Grisel from the Switzerland office of Bonnard Lawson. We also have Anne-Caroline Albrecht, who is in the Dubai office, and Jean-Philippe Mabru, who is in the French office. I'm excited to welcome them all, and I thank them for coming. Guillaume, I would like to pass it over to you to proctor this presentation.
Hello, ladies and gentlemen. We're very happy to be here. Many thanks to Dunhill Financial and to Brian to have us today. It's always a pleasure to share our experience on a topic we actually know quite well: estate planning for Americans living abroad. My partners, Jean-Philippe and Anne-Caroline, will speak specifically about US citizens residing in France and the United Arab Emirates. I'm based in Switzerland, but I'll give you some tips that I think are valid for all Americans living abroad. We have advised dozens of US families living all around the world, and we've noticed that there are a few questions that arise in 95% of the cases. So we're not going to make an exhaustive overview of all aspects of estate planning. It would be impossible anyway. Rather, we'll devote ourselves to these few points that almost always come up. We really hope they will be relevant for you. I think they will. Our first point today pertains to bequeathing assets to your spouse versus your children. Then we'll talk about trust. After that, if we still have time, I'll make a few remarks on mental incapacity planning documents. And at the end, Jean-Philippe and Anne-Caroline will address a few additional issues specific to France and the Emirates. Let's start with bequeathing assets to spouse versus to children. This is really a question that comes up all the time. When my US clients want to make a last will, almost all of them ask me this. I'm married, I have children. If I'm the first spouse to die, can I leave all of my assets to my spouse? Is it okay that the children only receive the family's wealth after the death of the second spouse? Or do my children have to receive something already when the first spouse passes away? This question reveals a fundamental cultural difference between the USA and continental Europe. And this cultural difference is reflected in the succession rules. Let me explain. In the US, when you make a last will, you're totally free to leave whatever assets you want to whomever you want. And usually, when the first spouse dies, he or she leaves all his assets to the other spouse. The children receive nothing at this stage. They have to wait for the death of the second spouse. In Europe, it's different. There are mandatory rules in the law that state that the children and the surviving spouse must receive at least a certain percentage of the estate. That's what is called forced heirship rules. So in Europe, when you make your last will, you're not totally free. You're not allowed to kind of disinherit your children. Now, why is it so? Believe it or not, in Europe, the law of succession dates back to the Roman Empire. Yes, 2000 years ago. And it hasn't changed much since then. At that time, when the husband died, the children inherited everything, and the widow received nothing. Not nice with the widow, the Romans? In fact, no, because she would be looked after by her own parents or brothers. That was the logic at that time. So that's where the whole forced heirship thing comes from. Now, you're American, you live in Europe. How can you leave as much property as possible to your spouse and not to your children? If that's what you want, of course. Well, there are different possible strategies, but not all of them work all the time. It depends on the country you live in. Let me give you a few examples. First, if you're a US citizen, it is generally possible to have your last will governed by US law instead of the law of the European country in which you live. In this case, forced heirship rules don't apply because you're under US law. But pay attention to one thing. Just because you opt out of the succession law of your country of residence doesn't mean that you can opt out of the local inheritance taxes. It would be too easy. But that's a very common misconception. Here's another strategy. In some cases, you can favor your spouse by making a marital property agreement, a prenup, or a postnup. In some countries, like Switzerland, parents and children can also make a succession agreement. It's like a last will, but in the form of a contract with the heirs. This way, the children can literally give up their forced heirship share by contract. Let me give you one last tip. As I said before, in many European countries, you can't bequeath absolute ownership over the whole estate to your spouse. But you can leave a usufruct right over the whole estate to your wife or husband. With a usufruct, your spouse won't own your assets, but they will be allowed to use them and benefit from them for the rest of their life. It's a bit like a life interest, if you like. All right, these were general remarks. Now, let's take the example of one typical European country with forced heirship rules, France. Jean-Philippe, how do US citizens living in France cope with these forced heirship rules?
If I'm muted, it's better. Thank you, Guillaume. Hello, everyone, and good morning. Welcome to Paris. France is not different from the other European countries. In fact, we are a civil law state, as you said, and we know the forced heirship rules, but maybe in a different way than in Switzerland or Italy or Spain, because the only protected heirs under French law are the children, not the spouse and not the parents. So there's only one class of heirs protected here by the forced heirship rules. There's also another point which is important in the French law, and it derives from the European succession regulation, which entered in force in 2015, which is the law applicable, the determination of the law applicable to the succession. We have in France, as in all over European countries, only one criterion for the determination of the law applicable to the succession. And this criterion is, in fact, the place of the habitual residence of the deceased, which means, in fact, the state or the country where he decided to live permanently on a stable basis. Meaning that if you decide to move to France and live in France, there will be one law and only one law applicable to your succession, French law. And French law will apply to the worldwide assets, including those located in the United States, which is very important here. And it means, of course, that the forced heirship rules will apply to the succession. We have a possibility, such as in Switzerland, in a different way, to avoid the application of French law, as you mentioned already, in the election for the law of the citizenship. And you can elect in the French will for US law to apply to your succession. And in doing so, the succession will be governed only by US law, excluding all of the rules and disregarding especially the US conflict of law rules. I mean, US law will govern everything, and the forced heirship will not apply anymore. So you'll be free to transfer all your assets to one of your heirs, not your children, but it can be your spouse, the surviving spouse, or one of them. So we have many examples of that, but it may be too long. So this is very shortly what we can say for France at this stage.
All right. Well, thank you very much, Jean-Philippe. Now, why don't we take a trip to the southeast and see what's going on in the Emirates? Over there, no forced heirship, I think, but we must deal with another tough piece of law, the Sharia. And Caroline, can you tell us about this?
Yes, thank you very much, Guillaume. Hi, everyone. Hello from Dubai. It is nighttime already here. Indeed, so Dubai, I mean, the Emirates is kind of a complex jurisdiction to deal with. It is mainly a civil law jurisdiction. So as any other civil law countries, we know the forced heirship rules, but on top of that, it is also a Muslim country where the laws are established based on the Sharia principle. So the forced heirship rules apply as for civil law countries, but under the principles of Sharia, and dictate very precise rule as to how you can pass on your assets to your family. Most of the time, it's also limited to your wife and children, but it provides quite surprising rule for those people who are not familiar with Sharia principle, such as, for example, allowing to distribute double the shares to boys rather than your daughters, and very limited shares to your wife, and you have a very limited portion left for you to choose any other beneficiaries for your estate. So it is very important to understand that the Sharia principle and the Sharia law apply on all your estate based in the UAE, whether you're American national or from any other country, and whether you're a Muslim or non-Muslim. And also, if you're a resident in Dubai, these principles might also apply on other of your assets abroad, because as Jean-Philippe explained, even if you have assets in the US or anywhere else, your jurisdiction where your assets are based might consider that the law of your last residence upon death apply to the distribution of your assets. So if you don't structure your assets, indeed, you might be subject to forced heirship based on Sharia principle. So again, this is for the question of forced heirship. There are several tools that we can use in the UAE to avoid application of Sharia. Will is one of them. UK, well, common law based will is also another kind of them. And we know also trusts and foundations. I think we will discuss that in details a little bit later.
All right. Thank you very much, Anne-Caroline. This was very enlightening. Now, are we ready to jump to our second big topic? Okay, the second big topic we want to discuss today is trusts. Clearly, the trust is the most flexible and versatile tool we have for estate planning. That's why Americans use it a lot. There are many reasons for setting up a trust, but I'll just discuss two of them. First, US married couples often set up a living trust. They are typically trustees or co-trustees for each other. Spouses mainly do that to simplify the succession between them. I'm sure many of you have a living trust in place. Well, that's a typical example of US-centric estate planning. It's true that it works well for assets located in the US, but sometimes it's quite the opposite for assets located in Europe or elsewhere in the world. I don't know if you're aware of this, but trusts are not well known in most European countries. Remember the Romans? They didn't have trusts. Neither do we. Using a foreign tool in a country where it is not well known can cause problems. We want to use estate planning tools like trusts to solve problems, not to create more. Now, I'm not saying you can never use trusts to hold assets in Europe. The truth is, it depends. It's just very important to carefully consider for each country and each asset whether the trust is the right solution or not. There's another common problem with US living trusts. We come across this problem all the time. It's a funny problem, by the way. People often don't really know which of their assets are in their trust or not. It's particularly true for assets outside of the US. This can obviously cause all kinds of difficulties and risks in terms of taxes, probate, sale, divorce, etc. So it may sound silly, but please, you need to be clear about which assets should be in your trust, but also about which assets are effectively in your trust. And keep in mind that the legal requirements for transferring assets into a trust are not the same in all countries and for all types of assets. Usually, at the end of a trust document, you've got a list of assets. Just adding one more asset on the list, bank account, property, is not sufficient For the asset to be legally in trust, there are additional legal requirements. Americans often want to set up trust for another reason, which is a very good one, by the way. They want a trust to be in place in case something happens to them while their children are still minors or young adults. You have to know that doing this is sometimes complicated in Europe. For example, in Switzerland, you can create a trust for your children during your lifetime, but not by testament. The fourth heirship rules we mentioned before can be an obstacle too. Now, I think it's time to take a break in sunny Dubai again. And Caroline, could you update us on trust in Dubai and the Emirates? I'm guessing that you might want to say a few words on foundations too.
Yes, thank you. Yes, indeed. So trust is a really well-known succession tool in America. Is way less known, well, less used and less common to be used in civil law countries. So the United Arab Emirates apply the same rule, and there have been really work on developing the trust laws within the Emirates. So just maybe a step back on how the Emirates are constructed in terms of jurisdiction. There are two kinds of jurisdictions in the UAE. There's the mainland jurisdiction, which is based on the civil law regime, and the free zones jurisdiction, two of which are the most well-known, which are the Dubai Financial Center, the DIFC, and the Abu Dhabi Global Market Center, which is also a financial center based in Abu Dhabi. Those two jurisdictions are common law based jurisdiction, and therefore their regulation is really easier to apply for American citizens. They have implemented trust laws, and recently even mainland UAE has implemented trust law to allow trust to be set up in the Emirates and to hold assets not only in the Emirates, in the entire MENA region, and also up to anywhere. There are no restrictions on what assets you can hold under a trust. So basically, the foundation is also a very good tool used in the UAE because it is a civil law tool. It is very much understood and applied by the court. And the similarities that we can find between trust and foundations are both for obviously succession planning. They are both portable tools, so you can, if ever you relocate somewhere else, you can relocate your tool. The founder could be an individual, but also a company. You have all kind of assets that you can hold under those tools, provided that you structure it well, also to avoid tax consequences. It can be created during the lifetime or upon your death. This is the main difference with a will, for example. And of course, the differences between foundation and trust are focused on the fact that there is no legal entity, no legal personality under a trust, while a foundation has a proper personality and hold the assets under their own name. The main difference, I would say, between a trust regime under US law and a trust that is known under the UAE laws is the fact that we hardly recognize the trust as being the legal owner of any assets. It is the trustee that owns the assets. And on top of that, in the UAE, specifically mainland, the trust has to be registered, and all the assets have to be registered as well, and are registered under the trustee ownership, even though, of course, the trustee has the duties imposed to him under the trust deed and so on. I don't know if there is anything regarding trust in the UAE that you would be interested to know, Guillaume. I would just make a comparison between the wills, because you spoke about the will before, saying that in Europe, and especially in France, you can apply US law. If you designate it in your will, I would say that in the UAE you can do the same. You just have to keep in mind always that basically it will be eventually a UAE court that will apply the same. So whenever there is a challenge on the application of the law, it is difficult for a local judge to apply a foreign country law, such as the US, for example. So I would say another alternative, which is a very good alternative as well, is the DAFC will. The DAFC will is based on common law practice. So it allows you complete freedom on your distribution of assets as per common law country. And based on that, it is easier, as the DAFC law is recognized within the legal framework of the entire UAE. So it is easier to apply the DAFC law rather than any foreign law to distribute your assets as you wish. The only difference, of course, is that you will need probate. Your assets are not protected; they are still under your name, so they're subject to your creditor's hand. And while the foundation or the trust really separate your ownership to your assets and create a kind of firewall between you and the protection of your assets, basically.
All right. Well, thank you very much, Anne-Caroline. I think this is perfect for the time being, and we'll see if there are questions on trust in the Emirates from the audience. One last comment on trust from my end. Beware of taxes. If you plan it right, the trust can sometimes result in tax savings. But careless planning can have disastrous consequences, and it is true in many countries. I think the timing is just perfect to go back to France for a minute while we're talking about tax disasters. It is often said that the French taxman doesn't like trusts. He likes to eat frog legs and snails, but he said not to like trusts. Is it true, Jean-Philippe?
Well, what is true, I'm sure you would say that. I was sure. What is true is that we don't know trust. And you cannot have in France trust. It does not exist any French trust. But this does not mean that we don't have any rules. We have rules, and we have important rules. And a big change was made in 2011 with a new taxation law and introducing a new taxation rules for foreign trust, not for French trust, but only for foreign trust. The first thing you have to know is that when you're a French resident, and I will only talk about succession, inheritance tax, because we don't have so much time, but we have also different kind of things regarding income tax and the wealth taxation. But as succession taxes, inheritance taxes are concerned, what you have to know is that when you're a French resident, you're subject to French taxes worldwide. And all the assets worldwide are taxed in France, even those comprised in trust. And we look trust for French inheritance tax purposes as transparent entities. And it is true that it is quite complex because nothing is really simple in France. We have, how can I say that? We have, in fact, we consider two different situations, and situation A and situation B. And in situation B, we have 4 different hypotheses. On situation B, this is the case, situation E, sorry, this is the case where the transfer of made through a trust can be considered as a succession or gift. Okay, so what does it mean? It means that all the assets at the time of the death of the settlor are distributed to the beneficiaries. If there is a distribution to the beneficiaries at the time of the death, then the trust transfer is considered as a succession and is taxed following the tax rates applicable between the beneficiary and the settlors, and the settlor following the family links or family ties, this thing between them. Situation B, this is quite easy, but you have to distribute everything. This is not usually the case, because in most of the situations, the trust assets are kept into the trust for the next generations. In situation B, this is exactly the contrary. It's when the trust transfer cannot be considered as a succession or a gift. And then in that case, you have three different kind of taxation. The first hypothesis in situation B is when defined share is allocated or to an identified beneficiary. So you have a very defined share, and this share is for a defined or designated beneficiary. We have in that case, in this case, we have a taxation following the normal inheritance tax rate, the usual inheritance tax rates. Same thing, the family link between the beneficiary, between the designated beneficiary and the settlor. The second situation, or the second hypothesis, is a transfer of an identified share globally to descendants. And we find often this kind of beneficiary clause in trust when you say that the trust assets will be devoted to the descendants of the deceased or the settlor or the original settlor at such time. In that case, this is different, and we have a specific taxation. The entire share is subject to a 45% taxation in France. After that, in all of the cases, we have a 60% taxation here. So if you don't have any identified share transferred to a designated beneficiary, which will be a usual taxation situation, if you don't have a global share, an identified share transferred to the descendants, all of the cases, including the transfer to the spouses with other beneficiaries, will be taxed at 60%. And there is a fourth one. The fourth one is when the trust is set up by a French resident. And here we have 60% taxation at the time of the death of the settlor French resident, whoever the beneficiaries could be. So even if you have designated beneficiaries who are the children, for example, or the spouse, and this is very important because you have also to consider that in France, transfer between spouses and civil partners are fully exempt from any tax, which will not be the case if you have a trust and you didn't pay enough attention to the beneficiary clause. Let's take just an example. If you have a succession without any trust, and the beneficiaries, the heirs, are for half the surviving spouse, and for the other half, one child, the surviving spouse will be fully exempt in France on his share, and the children and the child would be taxed, but with a maximum tax rate of 45%, exceeding 1.8 million euros. If you have the same thing for a trust, taxation will be of 60% of all the assets. So what you have to remember when you're talking about France and trust, is just pay high attention on how your beneficiary clause is drafted. Is it enough for you, Guillaume?
Absolutely. Thank you very much, Jean-Philippe. This was very enlightening.
Of course, it does not mean that you cannot move to France with a trust.
Thank you for adding
without
this.
A trust, yeah. With or without.
All right. Okay, well, to conclude on taxation of trust, maybe two last tips, which are very general. First, the solution often lies in the careful drafting of the trust documents. Second, your trust documents should always be reviewed by your local tax advisor, always, in your country of residence and in the countries where the assets are situated. So that was trust. Now, Anne-Caroline, do you have any other remarks or tips for the US citizens in our audience who live in the Emirates?
Yes, thank you. No, actually, I also wanted to mention a point regarding tax. I mean, UAE, as you might know, is a tax-free country, which is good. So we don't have to deal with tax all the time, as you do in France and in other places. But be careful that it is not because you can set up a trust, a foundation, that this will absolutely prevent you to pay tax. Unfortunately, as being a US national or as being US citizen, you will be bound to pay taxes even if your assets are based abroad and even if your assets are structured under a structure. So it has to be, as Guillaume mentioned, really properly planned, well drafted, well thought. There are several aspects where you can use UAE structuring for tax planning as well, but it has to be carefully thought. Yeah, definitely.
Okay, thank you. Now back to France again. Jean-Philippe, anything else Americans living in France should really know during this session? Not necessarily about trust, but really in general.
Really in general, I think I'll try to let you know that France could be a tax-free country also for US citizens. This might be strange, but this is the case. First thing, France has signed all double tax treaties with the US. We have a tax treaty for income tax and wealth tax, also for gift and inheritance taxes. So everything is covered by double tax treaties. And these double tax treaties provide for very specific rules regarding US citizens. I can take just a few examples. As income tax is concerned, we have what we call passive income. Passive income, or US passive income. Passive income is all income deriving from financial investments or real properties located in the US. This passive income, when you become a French resident, can be fully exempt from any tax in France, including the social contributions. Because in fact, what you get, this is quite difficult, but you have a tax credit deductible equal to the French taxes. So you don't pay anything in France on your US financial income and US income deriving from real properties. You pay only the US taxes, but nothing in France. There's also an exemption, a full exemption granted on US pensions. So if you take a situation which quite frequent with my clients, where the US citizen living in France has only income deriving from US securities, US stocks, or distributions made by US trusts investing in US securities, only income from US real properties, then there is absolutely no taxation in France. It is tax-free, and the only tax levy is in the US. The second thing, or the second point, concerns the wealth tax. We have a wealth tax in France, and you have to pay each year a wealth tax on the value of your real properties. When you become a French resident, this is worldwide. So all the properties, wherever located, are subject to the wealth tax, except for the 5 first years. And when you become a French resident, you are only taxed on your French real properties, but not on the foreign real properties. And the last point maybe will be on the inheritance tax. We saw that France has quite high level of taxation on inheritance, but following the provision of the French-US tax treaty on inheritance, you could be considered as still residing in the US and not becoming a French resident for inheritance tax purposes. You have many conditions for that, but in fact, we would consider that if you reside in France for less than 5 years and that you retain all your interests, personal and financial interest in the US, you are still considered, and you are a US citizen, you are still considered as US resident for inheritance tax purposes, which means that your succession, the estate, would be taxed in the US and not in France, except for French assets. So these are the last points that maybe we can have a look at as France is concerned.
All right, thank you very much. So France is a tax haven. Well, I've learned something today.
Absolutely.
Now I think Bonnard Lawson, the Bonnard Lawson team has probably talked enough today. So, well, I guess thank you very much for being such an attentive and gracious audience. We had a lot of fun and we hope you enjoyed the discussion too. I'll now turn the mic back over to our friends at Dunhill Financial